In June of 2021, recreational marijuana became legal in the state of New Mexico. Now, this wasn't just a free-for-all for total legalization of marijuana. There's a lot of aspects of possession, distribution, and depending on your age, where marijuana is still illegal or a civil penalty. Under the new law, this left a lot of questions for law enforcement. And here in 2023, I still get a ton of questions under the new statute, what's legal and what's not. In this episode of the podcast, I bring in Assistant District Attorney KirkWilliams. Kirk's currently a HIDTA attorney in the 5th Judicial District of New Mexico. All he does is drug cases. So I kind of turn this episode over to him and let him break down the statute. Now, before I turn it over to Kirk, I do want to give a quick disclaimer. Obviously, this is going to be an episode for my New Mexico officers. If you're an officer in another state, then obviously these laws are not going to apply to you. I still think you can take some value from this. Maybe you're in a state where legalized marijuana is coming, and this can give you maybe a bit of foresight in what it's going to be like. If you're in a state that's already legalized marijuana, leave some comments below. Let us know any issues that you're having in your jurisdiction. And finally, one last disclaimer. This is so new, as Kirk's going to talk about in this episode, that we're still trying to figure it out. So this is not legal advice. This is for informational purposes only. You should consult with your local district attorneys, your local city attorney, your county attorney, whoever your attorney is. Seriously, just consult with an attorney. Without further ado, let's dive in. Let's talk about legalized marijuana in New Mexico. Here's Kirk.
All right, so yeah, as Eric said, it's legalized. With the air quotes for those of you that are just listening. There are still several areas that are crimes, whether that be distribution, possession, the number of plants you have, where you're selling it, or where you're possessing it. And so I'm going to go through that. The legislature has kind of really taken away the probable cause aspect of it, the ability to get into vehicles, cars, houses by just seeing the marijuana. But they did not completely eliminate it. They just made it a little harder. And so I want to talk about all that. But I'm going to start with what I'm sure everybody's the most curious about, the possession. Simple possession. You catch defendant with just whether it be a couple grams, a couple ounces, or a couple of pounds. Let's talk about that. So the way that it's broken down in a lot of these statutes is actually by the person's age. They're kind of treating it like alcohol, and so the age cutoff is 21 for a lot of this. So starting with possession, if you're under 21 and you possess it, and it does not give a weight, so that could be a gram, an ounce, a pound, a kilogram, however much, it does not specify. It is a civil penalty. It is not a criminal penalty. And so the civil penalty is either a 4-hour drug school or 4 hours of community service. When you get over 21, that's when it becomes a criminal offense. And so up to 2 ounces of weed is completely legal. There's no problem. That is not a crime. Anything from 2 ounces to 8 ounces is a misdemeanor. And everything above 8 ounces is a felony.
That's what it used to be, right? Over 8 ounces was a 4th degree felony, right? Back in the old days.
I'm trying to remember. We didn't.
A third.
I believe it was a 4th, but we normally went on the distribution.
Yeah.
Because that carried a little bit more weight, and over 8 ounces. Nobody's really running around with 8 ounces for personal use, and so we would run under the distribution theory if it was over 8 ounces.
I swear this is for personal use.
Yeah, I got I got it at the Costco. Right. Why go back multiple times?
Now, when you talk about the civil penalties for under 21, how does an officer even do that? Is the court involved in this? Like, if they catch someone under 21 and they're in possession, how do they get them to go to the drug school or community service? Is it a judge? Like, where does this stuff get filed even?
So what we've been doing is it has been going through a lot of what we've been seeing has been under 18. And so it's been going through our JPO, our Juvenile Probation Office. And I believe they've been doing a lot of this, getting them into the drug school, getting them into the 4 hours of community service to satisfy this.
Got it.
Is my understanding of how we're doing this. So, the possession statute, as I've laid out, is pretty simple. The way that it is written is not simple, and I'll go into that here a little bit later on. But I do want to talk about distribution next. That is probably the second biggest thing our officers will see is the distribution. And again, this is again broken down by age, but the cutoff for this one is 18. And again, if you're under 18, it's that civil penalty again. It's that 4 hours of drug school, that 4 hours of community service. And now, over 18, it is a misdemeanor. And again, there's no weight given to this. So you could be, hand-to-hand selling a gram, an ounce, a pound, a kilogram, a truckload full. It does not matter. The way the statute reads, it is a misdemeanor. It does not matter how much you are distributing. It's a misdemeanor. The exception being, if you're over 18 and from basically a weed shop without a license. The statute's got a lot of legalese in it. But basically, if you're running a weed shop without a license, that is a fourth-degree felony. But, our normal hand-to-hand buys, how we're used to seeing drugs getting sold, that is just a misdemeanor. And it does not matter the weight. It's still a misdemeanor. A lot of what we're seeing, though, with regards to criminal, is in drug-free zones. We've got a lot of kids possessing. We've got a lot of kids distributing in schools. And that's basically how the statute reads is in a drug-free zone or a school. And it does not, this is one of the few statutes that is not broken up by age. It basically says if you possess or you distribute within a drug-free zone, it is a misdemeanor. Doesn't break it down by age. Again, it does not break it down, the distribution down by amount. So again, it seems like you could distribute a gram, a pound, an ounce, and it would still be the same penalty.
So what we're talking about there essentially is it's a school, but it's pretty much any school other than a post-secondary school. So we're talking about a college campus. Right.
So yeah, no, this is more geared to protect kids. If it does not apply to colleges, doesn't apply to universities. This is for your high schools, your junior highs, and God forbid your elementary schools.
So how would this apply to SROs that are working in the schools if they find a kid with a possession of a dime bag or something? Are they still calling it that?
Yes, they're still calling it a dime bag, and it is a criminal offense. Again, our SROs are shooting it through JPO, and our juvenile court attorneys, our children's court attorneys are taking those cases. So no, this drug-free zone statute, and it is just a misdemeanor, but it's given us the most teeth out of any of the other cases. I mean, this is what we're seeing the most. We're seeing just more and more kids with weed, with the THC vape cartridges, with stuff like that in the school. And because this does not have an age limit, it actually gives us a little bit of teeth to try to correct these actions.
So we're not just talking about, we're old school, we're used to seeing like good old-fashioned weed, but this applies to like all cannabis. Any THC product, because it comes in extract, it comes in the gummies.
Yes, and so we'll get into that a little bit more when we get into the possession statute. Yeah, we're talking about the extract, the gummies, the edibles, the brownies, and just good old-fashioned nugs of weed.
All right. Sounds good.
So I'm going to turn next to search and seizure, because again, that's another thing that you guys are going to have to deal with a lot. Again, I'm sure everybody's heard, you see weed anymore, that's not good to get in the car. And for the most part, that is true. But you can still get in the car by just seeing weed in a few circumstances. The first being is if you can articulate that there is over 2 ounces of cannabis, of the weed. And actually, I'm going to get a little bit more into the weeds, talking about the extract or the edibles. So the statute reads, if you can articulate that there is in excess of 2 ounces of cannabis or 16 grams of cannabis extract, which is the wax, the stuff they put into the vape, stuff like that, or 800 milligrams of edible cannabis.
Okay.
That is enough to get into that car. That is reasonable suspicion to get into that vehicle.
Now, when you say get in the vehicle, New Mexico doesn't follow the Carroll Doctrine, so this would be like asking for consent or exigent circumstances apply.
Yes, or getting a warrant. That's enough.
Getting a warrant, yeah.
Yes. So I always tell my officers if there's a question, just get a warrant. Especially here in New Mexico, those of you not in other states, you don't have that issue, but here in New Mexico, just get a warrant.
Yeah.
And so the other circumstance with seeing weed and being able to get into a car, either through exigent circumstances, a warrant, what have you, is during a DWI investigation. And during that DWI investigation, it does not matter how much you see in that vehicle. I know a lot of the times, back in the good old days, you could get into that vehicle with just seeing a roach. Now, if you pull somebody over, he's weaving all over the road, you get up there, he's got bloodshot, watery eyes, and you see a roach in the ashtray, you can get in that vehicle. You're doing a DWI investigation. He's exhibiting signs of driving while under the influence, and you can see cannabis openly in that vehicle, even though it is less than 2 ounces. For a DWI investigation, you can get into that vehicle.
Now, where does a DRE play into this? Have you seen, or since I haven't been in the courts in a couple of years, is the court requiring a DRE, or is a regular, normal patrol officer able to testify from training experience, person's under the influence of a drug, and that they can articulate that to get a search warrant to get into the vehicle, or is this something that you might want to rely on a DRE for?
So, I mean, if you've got a DRE handy, that's awesome. If you don't, I haven't had any trouble with the courts not honoring warrants from regular patrol officers. But again, you have to be able to articulate it. You have to be able to write it. You have to be able to convince the court that based on your training experience, based on this training, this experience, what you've done, that that this person is under the influence of marijuana. And because you can see the marijuana in their cup holder, in their ashtray, on their dashboard, wherever it might be, that is evidence of a crime that needs to be seized.
If you guys need a reminder on reasonable suspicion, especially and how it applies in New Mexico, I'm going to have it scroll up right about there. You might want to pause it and take a look at it just to buff up on the reasonable suspicion aspect and then kind of come back in, because nothing's really changed with that. You got to have reasonable, articulable suspicion that criminal activities afoot. We're just talking about with the new statute, how it changes that and what extra things you got to look for.
Yeah, and I cannot recommend buffing up on your reasonable suspicion, your probable cause enough. That is the bread and butter. That's going to get you guys 90% of what you need. Is that reasonable suspicion, that probable cause. So you cannot watch those videos enough. You cannot read enough on probable cause, on reasonable suspicion. So just one more quick note on the search and seizure. If you roll up on somebody's car and say they've got 8 dime baggies with very obviously less than 2 ounces of cannabis, that is not reasonable suspicion. Just because they've got multiple containers, that is not enough. You still have to be able to articulate how you know that it is more than 2 ounces.
So, and also in New Mexico, you got an officer that makes a traffic stop, and it's for a turn signal violation. You know that you're limited in New Mexico to only asking questions about the turn signal. Take a look at State versus Teuton. It Shows you how far the courts have really pushed that here. So you walk out, you see like a container or something looks like that it came from, I don't know what the official name is, the weed store, I guess we're referring to it as. That's not going to give you reasonable suspicion to expand into any other investigations. You have to articulate that it is over 2 ounces.
Right.
Based on facts that are available to you at that time.
Right. And I like to call them pot shops. But yeah, just because somebody has 8 prescription little pill bottles from the pot shop, that is not enough. You have to be able to articulate how you know that those 8 pill bottles of cannabis is over that 2 ounces. So I'm going to talk a little bit more about some stuff that's still a crime, but you're less likely to see. I guess something we haven't really seen too much, but it might become an issue as more and more of these pot shops open, and they will need weed to stock their
dispensaries.
Yeah, I know, but pot shop, it's just got a ring to it.
Okay.
So with plants, it's again broken down by age. It does not talk about under 18. It does not talk about minors possessing plants. It goes from 18 to 21, and then it talks about if it's less than 6, if it's 6 plants six less than 6 plants, it's a penalty assessment. It's a ticket. 6 to 12 plants is a misdemeanor, and then more than 12 plants is a 4th degree felony.
Does it matter where it's at? Is this in public, in your house, in your car?
The statute doesn't say. I mean, surely you can't, just be taking your plant for a walk.
Well,
but the statute is ambiguous. So looking at over 21, you're adults. If it's less than 6 plants, that's totally legal. No issues whatsoever, according to the statute. 6 to 12 plants is your penalty assessment. That's going to be your ticket. And more than 12 plants, it bumps right up to a felony for an adult. So we're not seeing a lot of these grows yet. But I'm assuming as more of these pot shops open up, they're going to need more inventory. People are going to take advantage of it. And we're going to see more cases with plants.
Yeah, we've seen that in California, where even though, they're one of the states that have had it legalized the longest, and there was still a big market for the illegal grow operations up in the mountains. So, not seeing it now, but that doesn't mean it might not show up at some point in the future.
Right. And, again, as these markets expand, as more people buy, as more inventory these shops need, I think it'll become more of an issue. So I'm going to get a little bit more into the weeds now. Talking about the possession statute, how it was written. As a lot of you know, the legislature was called into a special session to legalize marijuana. It was all written pretty quickly. And as you can imagine, there's some issues. Looking at the possession statute itself, we can see these issues blaringly. And that's in the misdemeanor part of the statute. Just to kind of read it out for you, basically, the statute states that between 2 and 8 ounces of cannabis, more than 16 grams of cannabis extract, and 800 milligrams of edible cannabis is a misdemeanor. Now you compare that to the felony, which is written correctly, where you have the over 8 ounces of cannabis, the more than 64 grams of cannabis extract, or the 3,200 milligrams of edible cannabis is a 4th degree felony. So looking at the misdemeanor statute, it reads as if you need at least 2 of those. Whether it be the 2 to 8 ounces, the 16 grams of cannabis extract, or the 800 milligrams of edible cannabis, the way the statute reads at the moment with the "and," it looks like you need at least 2 of them to charge that. Obviously, I don't believe that is the legislative intent. I believe it is just a Scribner's error. But that's how it's written right now, and that could be an issue going forward as we charge these cases. So I've had the opportunity to talk to several other HIDA attorneys, several other attorneys in different districts that are taking these cases. And obviously, if you're an officer watching this, or an officer or a deputy watching this, speak to your local drug attorney. Sure, your office should have a HIDA attorney or someone who primarily handles these cases, and kind of see how they're doing it. I know some offices they're not really messing with marijuana anymore. They'll if it's a bad guy, that's all we've got, we'll go for it. We'll charge him. We'll see what we can do. If it's just, oh my gosh, this is so much weed, we just opened up 8 semi-trucks full. We're probably going to roll with that. And then some offices are, oh man, this guy had 2.0001 ounces on him. We're charging him with the misdemeanor. So obviously talk to your DAs. See how they want to do this. See how they want to roll with it. We're here to work with y'all. Neither one of us can succeed without the other.
Excellent. What was I going to ask you? So, when I was the HIDA attorney, even 10 years ago, I had very few marijuana cases, and I didn't even like to do distribution. I just said, give me over 8 ounces, and I'll just do a simple possession. I tried to stay away from anything other than that. Now this has passed. You're in your role as the HIDA attorney. Since this has passed, are you taking any marijuana cases at your level?
So I've not taken any marijuana cases since this started. I was obviously taking marijuana cases before this started. Mm-hmm. Normally, it would be rolled into a much bigger charge. Mm-hmm. For the longest time, you'd walk up. An officer would walk up to a car, he'd smell marijuana. He would get into that vehicle either through a warrant, consent, something like that, and he would find the hard stuff. He would find, the methamphetamine, the heroin. And so, I'd have that possession, that trafficking of a controlled substance, but then, I would have the tacked on, then I also found a roach.
Yeah. And I think it's clear the legislator's intent was to legalize it. That's not really what it is. That's a whole different topic, but that was the intent of the legislator. So I think, Kirk talked about the search and seizure aspect. There's a whole other liability aspect. Can you be liable under HB4? Absolutely. Going to take some time to figure this out. So I think being cautious, working with your DA. I'm going to try to get Kirk's contact info, leave it here. If you guys have any questions, you can always reach out to me, reach out to Kirk. We got limited resources here in the Tactical In-Service Studios. My camera's already overheating. We've kind of got this to where I think we've kind of covered the basics and the key takeaways. So I'm going to invite you guys to leave comments and reach out. And let us know what issues you're having. So any final thoughts that wrap it up, put a bow on it?
No, I mean, I would absolutely love if you guys would leave comments. Just let me know what you're seeing. I hear a lot from the other HIDA attorneys. I hear a lot from the other drug attorneys. I don't get to see what you guys are seeing on the ground. So no, I'm super curious to see what you guys are seeing on the ground, what you guys are finding now that it's been legalized. And yeah, I'd love to open this up to a larger discussion. This is incredibly new. We're all just trying to find our feet with it. So no, I'd love to hear from you guys, and let's get the discussion started. I want to thank Eric for having me on. I'm very excited to kind of share what I've learned and see if we can't work together to get this sorted.
Thanks for coming. Don't forget, if you found some value, hit the subscribe button if you're watching this on YouTube. If you're listening to the podcast, follow us. Keep this thing going. Pass it around. Get it to all your friends. Pass it around. You like that? Thank Kirk for coming on here. I like doing this. And let me know if you want to see some more interviews like this in the future where I can bring another expert in to share some more value with you. So thanks, everybody. Appreciate it. Reach out with your questions. Don't forget to hit that subscribe button. Stay safe. We'll see you guys next time.